Much for your time. Good morning to you.
Good morning, sir. How are you?
I am fine. I hope you are too.
I'm fine. Fine.
I wanted to find out too. Is the job of the president to choose who should be chief justice? Ultimately, when a person is made chief justice, is it our choice or is the president's choice?
When the person is made chief justice, it's the choice of the people.
The choice of the people.
Mm-hmm.
But we didn't have a say in which of the justices should be picked.
We had,
How?
we had because the president nominates a person he wants or she wants to be chief justice, and then submit it to us through our representatives in parliament, and our representatives put that person, the nominee, to a process. And if they are satisfied that that nominee can be chief justice, they approve. So the president's duty is to nominate and not make a chief justice. Nominate a person who, in his view, can be chief justice. And then we subject the chief justice to a vetting process through our representatives in parliament and approve of that nomination. So it is our choice because we can refuse to approve of the chief justice.
I guess you were. No, you were not. I'm not sure. You were not in parliament when she was nominated and approved.
No, I was not in parliament.
But did you have any issues with her choice?
No, I didn't. I didn't because when she was nominated, I felt that having appeared before her when she was in the Court of Appeal and the way she was strict and ensuring that the counsel appearing before her was prepared, I thought she could bring that to the court. So I have no problem with her nomination.
Well, she's been there for, was it since 2023 when she's been chief
We went
justice?
to the Supreme Court in 2019
Okay.
until she was nominated in 2023 or so.
Okay. So from 2023 till these proceedings were started against her, were you impressed? What you thought was going to happen, did it happen? Were you impressed
No,
with
it
the
didn't
time?
happen. It didn't happen. So when she was nominated, I publicly said that the Chief Justice Torkornoo'S that I know, if she brings to the court the values that she held when she was at the Court of Appeal, not the Supreme Court, I said the Court of Appeal, she will make a good judge. I said it. But if she allows the office to change her, then it will be unfortunate. I said it. I mean, when you Google, you will see my comment. And unfortunately, she was brought under the hazards of light as a Supreme Court judge. And in my view, she failed.
She's failed.
She failed.
Is it
Many people have been disappointed. Many people.
as a Supreme Court judge, you think she's
As
disappointed?
a Chief Justice, many people
Okay.
have issues with her. Many people believe that she failed.
I see. How far does the press conference she addresses goes to worsen that or better that kind of view?
Well, so again, as a Chief Justice, you should know that when there are avenues, legitimate avenues for pursuing a claim, you don't go to organize a press conference and address the public on claims that can be addressed through the court process. And I have said elsewhere that if she were a judge sitting in the Supreme Court as a single judge and parties to a matter before her felt dissatisfied with the way she was conducting the case and came out and held a press conference detailing what was happening in her court, that would constitute contempt of her court. That would constitute contempt. And so I'm of the view that what she did is contemptuous of the committee.
What she did was contemptuous.
Yes, of the committee.
What about what she did was contemptuous?
You first of all, the committee sitting is supposed to be in camera, and when you come out and say things which clearly brings or brings into the public domain matters that are supposed to be in camera, it's not only contemptuous of the committee, it's also a violation of an express provision of the Constitution. That's number one. Number two, to pick and choose the proceedings that were happening in the committee is also contemptuous of the committee. Number three, to expose where the committee was sitting is not only unfortunate, it's also a breach of secrecy. Because until she said that previous Article 146 hearings were done at the Supreme Court, I, for the life of me, never wanted to know where the committees were sitting. And let me hasten to add, the whole Article 146 is modeled on trust. On trust. That when the citizen of this country sends a petition to the president, that we trust that the president will follow the Constitution. If it is against the removal of, or if it is for the removal of a justice of the Supreme Court, we trust that the president will refer the petition to the Chief Justice. If it is for the removal of a Chief Justice, we trust that the president will refer the petition to the Council of State for the determination of the prima facie. If the prima facie is determined, we trust that the committee will so advise the president, and the president will take action. That if the committee is constituted, we trust that the committee will do justice in the matter. It's a whole matter of trust.
But when you listen to her tone, she does not, first of all, it seems she does not trust the president, does not trust the Council of State, even her colleagues who are part of the committee, she does not trust at all.
That is why many of us have come to the conclusion that what she did was simply to court public sympathy, but not deal with the law.
Court public sympathy.
Yes, she was courting public sympathy. Because what she did clearly has no legal consequences on the committee, cannot impact the committee. And so what was the purpose, if not to court public sympathy?
Because she was complaining of the fact that she hasn't as yet seen the prima facie determination, the grounds on which it was made. She is also complaining about the fact that the committee has not served her with copies of the petition, because she's not sure if what the president gave to her is the same thing that the committee has.
So you see, when I say the whole Article 146 is modeled on trust, a trust relationship between the people, the head of state, and the committee, what she did was to undermine that trust, to chip away the integrity of the process. That's all the strategies here adopted. Undermine the trust and chip away the integrity of the process. She thinks that by doing that, she will create a legitimacy problem for the committee. Because when she wrote for copies of the petition, copies were sent to her. She asked for 10 days to respond. The president gave her 10 days. She asked for 7 days. The president gave her 10 days. So what petition did she respond to? What were her responses about? Number two, she's a judge. She knows that when you are served with a process in the nature of a petition, your immediate attention is to look at the contents of the petition and start preparing your defense. If the petition does not disclose a reasonable course of action, that is your defense. If the petition, in your view, does not disclose prima facie, that's your defense. If the petition raises matters which are exclusively within your possession, you have a duty to explain those factors and rebut, because the matters contained in the petition raises presumption of wrongdoing. And the presumption of wrongdoing is a rebuttable presumption. And so, if you take the petition, all you have to do by way of defense is to rebut the presumptions raised in the petition. That's a strategy. That's a defense strategy. So if the committee comes to the conclusion, the Council of State comes to the conclusion that the petition raises prima facie, all you have to do is to go back and look at your defenses, your first defenses, and strengthen them. Strengthen your defenses. Because the prima facie is just that you have to offer an explanation. And the explanation must be reasonable. That's the meaning of prima facie. To rebut that presumption. If the Council of State has said that it doesn't raise any prima facie, your preliminary strategy of addressing the concerns of the petitioners would have been upheld. That look, I don't think that this matter is a matter we need to go in. But somehow, she felt that she would rely on partisan political consideration, especially from the opposition party, to defend her. That was a wrong strategy.
So you're saying, if what she's saying about the petition is right, in terms of her saying there are no strong grounds in the petition of one of the petitioners for a removal, it is to her advantage. She needs to plead that before the committee and not come in.
But that's all. That's all. When Loretta Lamptey was subjected to the Article 146 proceedings, there were two petitions against her. One by Richard Nyama, the other by Anodam Press. Anodam Press petition did not raise prima facie. But Richard Nyama's petition raised prima facie. If Loretta Lamptey had simply considered only the Anodam Press petition, should have been caught, and probably that's why she was caught. Because Richard Nyama's petition raised prima facie. And she couldn't defend herself. So she was removed from office.
Well, I see. In fact, there's one opinion. In fact, this opinion has been expressed by both Comrade Kwesi Pratt and also by Solomon Owusu. They are of the opinion that this whole press conference that she organized is a loud message that she's not qualified to continue to hold that position as Chief Justice.
Yeah, you see, because I have spoken on the matter of trust, I trust the committee to do justice in the matter. I don't want to preempt the conclusions of the committee. What I will please Comrade Kwesi Pratt to do is to hold his horses. The trust relationship between the people of Ghana and the committee set up under Article 104 to inquire into the allegations raised in the petition must be maintained. And let's wait for the recommendation of the committee.
But you would accept that their conclusions are germane, because if this is the lady who administered the oath of the speaker, administered the oath of the president and the vice president, so somehow she's supposed to be the vanguard of the Constitution. You talk about a violation of the express provisions of the Constitution. That should be ground enough for us to decide that you do not deserve to hold this Constitution or protect it on our behalf. Should that not be?
So I have said elsewhere that our idiosyncrasies cannot operate to remove a justice of the Superior Court of Judicature from office. A justice of the Superior Court of Judicature, including the Chief Justice, can only be removed from office by Article 146(1) provision. That is, any citizen of Ghana who can demonstrate gross misconduct, incompetence, and in the case of a Chief Justice, incompetence in the administration of justice and the delivery of justice, or an infirmity of body and mind which renders her incapable of performing her duties. These are the only grounds on which the the committee can recommend, if it comes to the conclusion that those grounds have been made out, the removal of the Chief Justice. Whatever we think, whatever we say, will not operate to remove a justice of the Superior Court of Judicature from office. That is why I have said, can you imagine that the president himself must act on a petition? The president has no jurisdiction, original jurisdiction, to send a petition to the Council of States to remove a Chief Justice, even though he is a citizen of this country. He has no such jurisdiction. It is only a citizen of the country that can invoke the jurisdiction of the president to remove a Chief Justice. So, as I have said, and I still say it on your network, the design of Article 146 is intended to protect justices of the Superior Court of Judicature and regional tribunals. Because every provision you read has limitations on the executive authority of the president.
So you're saying trust the process?
Trust the process. That's what we are saying. Trust the process.
But
and insulate the process against partisan political consideration. That is why, since 1969, the constitutional experts that drafted the 1969 Constitution said we should insulate the process against partisan political considerations. Since 1969. That is why they did not recommend in 1969 that a petition received by the president from a citizen of Ghana should be submitted to Parliament for the determination of a prima facie. That is why they did not recommend that a petition received by the president from a citizen of this country for the removal of the justice of the Superior Court of Judicature must be taken to the Supreme Court for the determination of a prima facie. But it recommended that a petition so received must be sent to the Council of State. And it is instructive to note that the 1969 Constitution was our first attempt at creating a Council of State, which will have the consideration of the state, the interest of the state, paramount.
See, but can this, what people see are obvious violence that she's done to the process, be part of perhaps the reasons the committee can recommend her removal?
No, it will be external.
Not even if I send a petition to them saying that.
You can send a petition now. You can send a petition.
Oh, okay.
But the committee cannot on its own consider what she has done. It will bring it into the committee, what is not before the committee.
Alhaji, I recall famously the Agojo matter when the what they call it, the matter of the treason trial, when he was granting interviews among others, the judge on record told him to stop. There's also a matter of one of my colleagues who went into a court of one of the justices, a high court, and then the justice was of the opinion that the video that they played on their TV station a day earlier was an old file, and that they should have indicated that that video came from, is it the archive file of the TV station, because they didn't do that. The justice actually held him in some small distant cell for a few hours. So even though it's extraneous, on record, the judiciary has had cause to deal with people who have acted outside of the processes.
So if the video was shown on a TV station, this is how the law works. If the video was shown on the TV station and brought to the attention of the judge, that doesn't become extraneous now.
The judge saw it herself.
She said it herself.
Yeah, she saw it herself.
What I'm saying, no, she saw it herself, but she couldn't raise it by herself. She couldn't raise, somebody had to raise it. A lawyer had to raise it. But she couldn't raise it herself. That would be external.
I see.
You understand?
I see.
Someone will have to bring it to her attention.
Okay.
So for her to rule. But she cannot on her own go and raise it. No, it will be external.
Alhaji, thank you. Thank you very much for speaking to us. But are the rains holding up in the north?
Yes, they have held out for some time.
Oh,
and I think that nature, in his own wisdom, has done that to allow farmers to plow their fields. Because the way the rains were coming, the grounds were very soggy. And so it was difficult to plow the field. But I think that God, in his own wisdom, has held up the rain to allow farmers to plow their fields.
Thank you. Thank you, Alhaji, for speaking to us.
You're welcome.
ALHAJI INUSA FUSEINI is former of Parliament for Tamale Central, former Minister for Roads and Highways, former Minister for Lands and Natural Resources, joining us on the line. We'll also be having further conversations on this matter.